Section 8. Cross-claim. What is a cross-claim? A cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Such a cross-claim may cover all or part of the original claim. Section 8, Rule 6. A cross-claim may include a claim that the party against whom it is asserted is or may be liable to the cross-claimant for all or part of the claim asserted in the action against the cross-claimant. Q. D and E are solidarily indebted to P for $500,000. P filed a collection case against D and E for $500,000. D filed his answer in which he alleged that he had already paid $500,000 to P prior to the filing of the complaint. Judgment rendered in favor of D and E, dismissing P's complaint. The court finding that D had already paid P even prior to the filing of the case. The judgment became final and executory. D then files an action to collect $250,000 from E as reimbursement. E files a motion to dismiss on the ground that D should have filed his claim as a cross-claim in the collection case filed by P. Should the court grant the motion to dismiss? Answer: yes. A cross-claim not set up is deemed barred. Section 2, Rule 9. D should have filed in the first case a cross-claim against E for reimbursement. Q. Is there such a thing as a permissive cross-claim? In a sense, yes. A cross-claim which either matured or was acquired by a party after serving his pleading is not compulsory. That is Section 9, Rule 11. Namarco versus Federation of Namarco Distributors, 49 SCRA 238. Q. D and E are jointly and severally indebted to P under a promissory note for $500,000. P sues D and E before the RTC. D filed a cross-claim against E to recover $450,000 arising from the non-payment of the price of a car sold and delivered by D to E. Is the filing of the cross-claim proper? Answer is no. A cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Section 8, Rule 6. Here, the cross-claim is not proper since the claim by D against E did not arise out of the loan transaction subject of the complaint. Hence, the court cannot take cognizance of the cross-claim. Q. P filed a case against D and E. D filed a cross-claim against E. E did not answer the cross-claim. May D move to declare E in default of the cross-claim? The answer is yes. E should answer the cross-claim, otherwise he may be declared in default of the same. Under Section 3, Rule 9, the claiming party may move for default in case of failure to answer of the defending party. The cross-claimant is a claiming party, while the cross-defendant is a defending party with the purview of the rules of court. Section 1, Rule 3. Compare with the rule that the opposing party cannot be declared in default for failure to answer a compulsory counterclaim. Q. P filed a case against D and E. D filed a cross-claim against E. May E in his answer to the cross-claim assert a counterclaim against D's cross-claim? The answer is yes. The cross-defendant can file an answer to the cross-claim, and he may plead in the answer a counterclaim or a cross-claim. See Old Section 10, Rule 6. Q. D and E are solidarily indebted to P for $500,000. P filed a collection case against D and D for $500,000. D and E filed their answer alleging the defense of prescription. Judgment rendered in favor of P, and the same became final and executory. D pays the $500,000 to the sheriff. D then files an action to collect $250,000 from E. E files a motion to dismiss on the ground that D should have filed his claim as a cross-claim in the collection case filed by P. Should the court grant the motion to dismiss? This time the answer is no. The cross-claim is not compulsory, but permissive, since D's right to reimbursement arose only after he had served his answer. Prior to paying P, D did not yet have the right of reimbursement as against E. Q. D borrowed 500,000 from P with X acting as the surety. D did not pay on maturity, so P sued D and X. Judgment rendered in favor of P as against D and X for 500,000. The bank account of X was garnished in the amount of 500,000. X demanded indemnification from D, but the latter did not pay X. X sued D for indemnification. D argued that X's claim for indemnification was waived since he did not raise it as a cross-claim pursuant to Section 2, Rule 9. Is D's argument meritorious? The answer is no. The cross-claim was merely permissive since X's right to indemnification only arose after he had paid D. Also, under Section 35, Rule 39, when a judgment is upon an obligation of one of the parties as security for another, and the surety pays the amount or any part thereof, either by sale of his property or before sale, he may compel repayment from the principal. Q. S unlawfully ousted O from his parcel of land. S then sold and delivered the land to B. O files an action for reconveyance since S and B against S and B. Judgment was rendered in favor of O. The judgment became final and executory. Later on, B filed an action for breach of warranty against eviction against S. S moved to dismiss on the ground that the action was barred since B should have raised the same as a cross-claim against S in the reconveyance suit. Should S motion to dismiss be granted? No. A cross-claim which matured or arose after the defendant had served his answer is permissive and not mandatory. That should be arose, not arouse. Here, B's cross-claim for breach of warranty against eviction arose only after a final judgment had been rendered in the reconveyance suit. Under the law on sales, the warranty against eviction cannot be enforced until a final judgment has become rendered, whereby the vendee loses the thing acquired or a part thereof. Articles 1548 and 1555, the Civil Code. Hence, the cross-claim is not barred. Q. Is a cross-claim subject to the payment of a docket fee? A cross-claim filed before the MTC is not subject to a docket fee, but one filed with the RTC is. Q. P filed a complaint for collection of $1 million loan against D&E before the RTC of Manila. D filed a counterclaim against P for $500,000 for moral and exemplary damages, claiming that the filing of the suit was malicious and baseless. D also filed a counterclaim against P for $450,000 arising from the unpaid price of a car sold by D to P. In the meantime, D also filed a cross-claim against E for indemnification, contending that the loan was really incurred for the benefit of E only. No docket fees were paid on the counterclaims and cross-claims. A. Is D liable to pay docket fees on his counterclaims? B. Is D liable to pay docket fees on his cross-claim? Answer to letter A. D is not liable to pay docket fees on his counterclaim for $500,000 since the counterclaim is compulsory. Collection of docket fees on compulsory counterclaims has been suspended by the Supreme Court in its 21st September 2004 resolution. D is liable for the payment of docket fees on his counterclaim for $450,000 since the same is a permissive counterclaim. Letter B. D is liable to pay docket fees on his cross-claim, which was filed before the RTC, pursuant to Section 7, Letter A, Rule 141. The Supreme Court did not suspend the collection of docket fees on cross-claims filed with the RTC. Distinguish a counterclaim from cross-claim. A. Number 1. As to whom directed. A counterclaim is directed against the opposing party, while a cross-claim is directed against a co-party. Number 2. As to connection with the main action. A counterclaim may or may not arise out of the transactions constituting the subject matter of the opposing party's claim, while a cross-claim always arises out of the transaction or occurrence that is the subject matter of the original action or of a counterclaim therein. Number 3, as to compulsoriness. A counterclaim may or may not be compulsory, while a cross-claim is always compulsory. As for a need to answer, a counterclaim need not be answered if the counterclaim is compulsory, while a cross-claim must be answered. Otherwise, the party against whom it is pleaded may be declared in default upon motion. Section 10. Reply. A reply is a pleading, the function of which is to deny or allege facts in denial or avoidance of new matters alleged in or relating to an actionable document attached to the answer. When a plaintiff file a plaintiff may file a reply only if the defending party attaches an actionable document to his answer. Q. Is there a need for the plaintiff to file a reply? No. The reason is that even if a plaintiff does not file such reply, all the new matters alleged in the answer, including those alleged in or relating to an actionable document attached to the answer, are deemed controverted. If the plaintiff wishes to interpose any claims arising out of the new matters so alleged, he shall set forth such claims in an amended or supplemental complaint. Section 10, Rule 6. When is there a need for the plaintiff to file a reply? If the defending party attaches an actionable document to his answer, and the plaintiff wishes to contest the genuineness and due execution of the actionable document, he should file a reply thereto. Section 10, Rule 6. Such reply must be verified in accordance with Section 8, Rule 8. Otherwise, the genuineness and due execution of the actionable document are deemed admitted by the plaintiff. Q. When may the defendant file a rejoinder? If an actionable document is attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. Section 10, Rule 6. Section 11, Third-Party Complaint. What is a third-party complaint? A third-party complaint is a claim that the defendant may file against a person not a party to the action for contribution, indemnification, subrogation, or any other relief in respect of his opponent's claim. The defendant should obtain a leave of court in order to file a third-party complaint. How about a fourth-party complaint? A fourth-party complaint is a claim that the third-party defendant may file against a person not a party to the action for contribution, indemnification, subrogation, or any other relief in respect to his opponent's claim. The third-party defendant should obtain leave of court in order to file a fourth-party complaint. Q. Distinguish a third-party complaint from a third-party claim. As to its nature, a third-party complaint is a pleading, while a third-party claim is not a pleading but an affidavit or paper. As to who files, a third-party complaint is filed by a party to a case, while a third-party claim is filed by a stranger to the case. As to purpose, the purpose of a third-party complaint is for the defendant to bring in a stranger as a party to the case, while the purpose of the third-party claim is for the third party to notify the sheriff of his right or claim over the property attached, levied, or seized by the sheriff. Illustrate each of the grounds for a third-party complaint. Contribution. If D and X are liable for tort against P, and the latter sued D only, D may file a third-party complaint against X for contribution since joint tortfeasors are solidarily liable under Article 2994 of the Civil Code. Indemnification. P sues the surety to recover the loan the latter had guaranteed. The surety may file a third-party complaint against the principal debtor for indemnification. At any rate, a judgment against the surety is also binding upon the principal debtor who had notice of the action or proceeding and an opportunity at the surety's request to join in the defense. Section 46, Rule 39. Manuel V. Moran comments on the Rules of Court, 346. Subrogation. X recklessly drives his car and collides with P's car, destroying it. P sues the insurer to recover damages on his car insurance policy. The insurer can file a third-party complaint against X since it would be subrogated to the rights of the insured upon payment to the latter. Other relief in respect of his opponent's claim. P sues D to recover real property. D may file a third-party complaint against X, who sold the real property to him, for breach of warranty against eviction. Article 1548 Civil Code. Insured sues insurer to recover on a policy issued by the latter. The insurer may file a third-party complaint against the reinsurer. Q. When may the third, fourth, etc. party complaint be denied admission? The third, fourth, fifth, etc. party complaint shall be denied admission and the court shall require the defendant to institute a separate action, where A, the third or fourth, etc. party defendant, cannot be located within 30 days from the grant of such leave. B, matters extraneous to the issue in the principal case are raised. Or C, the effect would be to introduce a new and separate controversy into the action. What is the test to determine the propriety of a third-party complaint? The test to determine the propriety of a third-party complaint is to ask the following questions. 1. Is a third-party defendant's liability to the third-party plaintiff premised on the latter's liability to the plaintiff? Number 2. May the plaintiff directly assert a claim against a third-party defendant? An affirmative answer to any of these questions means that the third-party complaint is proper. Q. A bank lent money to a company. The money lent was misappropriated by certain officers of the company. In the collection suit filed by the bank against the company, may the latter file a third-party complaint against the erring officers? The answer is no. A third-party complaint is, under the rules, available only if the defendant has a right to demand contribution, indemnity, subrogation, or any other relief from the supposed third-party defendant in respect to the plaintiff's claim. Section 1, Rule 12 of the Rules of Court. Here, the officers of the defendant corporation had nothing to do with the loan of defendant corporation with the bank. Consequently, they cannot be made parties defendant in a third-party complaint. It's in the case of Commercial Bank and Trust Company versus Republic Armored Car Service Corporation. 8 SCRA 425. Q. Rufino is indebted to Simplicio in the amount of $400,000 payable on 31st of December 2007. To meet the obligation, Rufino had saved $200,000 by January 2007. During that month, Rosendo was able to borrow the $200,000 from Rufino after having been warned that Rosendo should return the $200,000 to Rufino before 31st of December 2007. In February 2008, Simplicio sued Rufino for the collection of his credit. Rufino pleaded in his answer that he was ready to pay $200,000 to Simplicio and reciting his transaction with Rosendo. He filed a third-party complaint against Rosendo for the recovery of the $200,000. Is a third-party complaint admissible?
The answer is no. The third party complaint is not admissible. Under Section 11, Rule 6, a third party complaint is available only if the defendant has a right to demand contribution, indemnity, subrogation, or any other relief in respect to his opponent's claim. Here, the right to demand relief by Rufino against Rosendo was not in respect to Simplicius' claim against Rufino. Hence, the third party complaint is not admissible. Q. B and C borrowed 900,000 from A. The promissory note was executed by B and C in the joint and several capacity. B, who received the money from A, gave C 450. C in turn loaned 225 out of the 450 he received to D. B. In an action filed by A against B and C with the Regional Trial Court of Quezon City, can C file a third-party complaint against D for the amount of 225,000? The answer is no. C cannot file a third-party complaint against D for the amount of 225,000. C's claim against D is not in a way of a claim for contribution, indemnity, subrogation, or other relief in respect to A's claim. The loan by C to D is separate and distinct from the loan of A to B and C, nor may A directly assert a claim against D. Q. Plaintiff lent money to D with S acting as surety. S acted as surety upon a counterbond given by X, which counterbond would answer to S in case he is held liable upon the loan. D was unable to pay plaintiff, who sued D and S. May S file a third-party complaint against X? The answer is yes. The third-party complaint by S against X is in respect to P's claim against S. X liability to S is premised upon S liability to plaintiff. Q. D borrowed 500,000 from P with X acting as the surety. D did not pay on maturity, so P sued X. Judgment rendered in favor of P as against X for 500,000. The bank account of X was garnished in the amount of 500,000. X demanded indemnification from D, but the latter did not pay X. So, X filed a suit seeking indemnification from D. D filed a motion to dismiss, arguing that X should have filed a third-party complaint against D, and not having done so, the action for indemnification is barred by res judicata or waiver. Should the motion to dismiss be granted? No. Unlike a compulsory counterclaim or a cross-claim, the filing of a third-party complaint is not compulsory and has no preclusive effect. Hence, X's claim for the indemnification against D is not barred by res judicata or waiver. Q. Paras was a passenger of a bus operated by Inland. The Inland bus was bumped by a Philtranco bus negligently driven by its driver. Paras suffered injuries and incurred substantial hospitalization and medical expenses. Paras filed with the RTC a complaint against Inland based on contract of carriage. Inland, with leave of court, filed a third-party complaint against Philtranco based on quasi-deli. The RTC rendered the judgment absolving Inland from liability and finding that the collision was due to the negligence of the Philtranco driver. The RTC ordered Philtranco to pay damages to Paras. On appeal, Philtranco challenges the decision, contending that it cannot be held liable directly to Paras since Paras' suit is against Inland and is based on culpa contractual, while Inland's third-party complaint against it is based on quasi-delict. Philtranco argues that since it was merely subrogated to Inland, there should first be a finding of Inland's liability to Paras before Philtranco can be held liable. Is Philtranco's argument correct? The answer is no. Under Section 11, Rule 3, a third-party complaint is a claim that is a defending party may, with leave of court, file against a person not a party to the action for contribution. indemnity, subrogation, or any other relief in respect of his opponent's claim. Under this rule, a person not a party to an action may be impleaded by the defendant either A. On an allegation of liability to the latter, B. On the ground of direct liability to the plaintiff, or C. Both A and B. The situation in A is covered by the phrase for contribution, indemnity, or subrogation, while B and C are subsumed under the catch-all or any other relief in respect to his opponent's claim. It is worth adding that allowing the recovery of damages by Paras based on quasi-delict, despite his complaint being upon contractual breach, served the judicial policy of avoiding multiplicity of suits and circuity of actions by disposing of the entire subject matter in a single litigation. Field Tronco Service Enterprise versus Paras, April 25, 2012. Ancillary jurisdiction over third-party complaint. Q. D and E are solidarily indebted to P for 500,000. The debt is due and outstanding. P sues D for 500,000 before the regional trial court. D filed a motion for leave to file a third-party complaint against E seeking contribution of 250. Should the court grant the motion even though the amount of the claim does not exceed 300,000? The answer is yes. Where the regional trial court has jurisdiction over the main case, it has auxiliary jurisdiction over the third-party complaint, even though the amount claimed falls below the jurisdictional amount. A third-party complaint is merely auxiliary and is a continuation of the main action. Republic versus Central Surety and Ins. Company 25 SCRA 641. Antonio R. Bautista, Basic Civil Procedure. Note, it is believed that the doctrine of ancillary jurisdiction should also be applicable mutatis mutandis to cross-claims. Q. In an action brought by PCIB against RM and XY before the Metropolitan Trial Court of Manila, XY interposed a counterclaim of 450,000, a cross-claim against RM for 500,000, and a third-party complaint against DE for 425,000, all of which were dismissed. Upon proper motions for lack of jurisdiction, discussed the merits of the said order of dismissal. The order of dismissal with respect to the counterclaim is proper because the counterclaim must be within the jurisdiction of the court, both as to its nature and amount. It is submitted that the dismissal with respect to the cross-claim and third-party complaint is also proper. It is believed that the doctrine of ancillary jurisdiction is not applicable if what is involved is a main action filed with the Metropolitan Trial Court rather than a regional trial court, since the amounts of the cross-claim and third-party complaint would be above rather than below the jurisdictional amount. It is also difficult to conceive how a third-party complaint, which is for contribution, indemnity, subrogation, or other relief, would exceed the amount of the plaintiff's claim. Dean Mariano Magsalin is of the opinion that the MTC has jurisdiction over the third-party complaint, invoking the doctrine of ancillary jurisdiction as set forth in Republic versus Central Surety and Insurance Company. In Republic versus Central Surety and Insurance Company, however, the main complaint was filed with the court of first instance, and the third-party complaint was for an amount falling below the then jurisdiction amount of 10,000. In the given bar problem, the amount of the third-party complaint falls above the jurisdictional amount of 400,000. Q. P filed a complaint against the surety with the RTC of Manila. The surety then filed a third-party complaint against X, who had executed an indemnity agreement undertaking to indemnify the surety in case it becomes liable under the surety bond. X filed a motion to dismiss the third-party complaint on the ground of improper venue. X pointed out that the indemnity agreement between the surety and X contains a provision that any suit arising from the agreement shall be solely and exclusively filed in Quezon City. Should the court dismiss the third-party complaint,
The answer is no. A third party complaint is ancillary to the main case. Thus, a third party complaint has to yield to the jurisdiction and venue of the main action. Eastern Assurance and Surety Corporation versus CUI, TRL 54452, July 20, 1981. Q. CCC Insurance Corporation issued a surety bond in favor of Kawasaki Steel Corporation to guarantee the repayment of the advance made by Kawasaki to FFM Construction. Upon failure of FFM Construction to repay Kawasaki, Kawasaki demanded payment on the surety bond against CCC Insurance. CCC Insurance denied liability and refused to pay, raising the defense of novation and the principal obligation. Kawasaki sued CCC Insurance, which filed a third-party complaint against FFM Construction for indemnification. FFM Corporation was declared in default with respect to the third-party complaint. Judgment was rendered in favor of Kawasaki against CCC Insurance on the main complaint and in favor of CCC Insurance against FFM Construction on the third-party complaint. On appeal, may the third-party complaint against FFM or corporation be dismissed for lack of cause of action? The answer is yes. The rights to indemnification and subrogation of a surety arise only upon its payment of the obligation to the obligee. In the case of bar, since CCC Insurance has refused to acknowledge and pay the obligation to Kawasaki, under the surety bond, it has not yet acquired the rights to seek indemnification from FFM Construction and subrogation to Kawasaki as against FFM Construction. In the same vein, the corresponding obligation of FFM Construction to indemnify CCC Insurance has yet to accrue. Thus far, there is no act or omission on the part of FFM Construction which violated the right of CCC Insurance and for which the latter may seek relief from the courts. In the absence of these elements, CCC Insurance has no cause of action against FFM Construction. Resultantly, the third-party complaint of CCC Insurance should be dismissed. CCC Insurance Corporation versus Kawasaki Steel Corporation, 2015, June 22. Note, the ruling is arguable. In effect, it holds that the surety may sue the principal only after it had made payment to the obligee, either voluntarily or through execution, thereby depriving the surety of the right to resort to a third-party complaint against the principal and negating Section 11, Rule 6, purpose of avoiding multiplicity and circuitry of suits. In fact, under Section 46 R39 or Rule 39, the surety need not even file a third-party complaint against the principal but can simply give him notice of the action or proceeding, in which case the principal is also bound by any judgment rendered against the surety. Under FRCP 14, a defending party may, as third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the main or the claim against it. Similarly, Section 8, Rule 6 provides that a cross-claim may include a claim that the party against whom it is asserted is or may be liable to the cross-claimant for all or part of a claim asserted in the action against the cross-claimant. This provision that a cross-claim may be filed against a party who may be liable to the cross-claimant is applicable mutatis mutandis to a third-party complaint. Third-party complaint, independent and distinct from main complaint. So the note is, of course, from the author of this book, Attorney Riguera. Q. P filed an action to recover on his insurance claim against insurer D. They filed a third-party complaint against the reinsurer E, which was allowed by the trial court. Judgment was rendered in favor of P in respect of his complaint against D, and in favor of D on its third-party complaint against C. Only D appealed from the judgment against it. May D move for the execution of the judgment on the third-party complaint against C? Yes, a third party complaint is independent of and distinct from the complaint. Hence, the judgment on the third party complaint may become final and executory without waiting for the final determination of the main case. Pascual versus Bautista 33 Scra 301. E should have appealed the judgment against it if it still wanted to contest the same. Q. B filed a case against D. D filed a motion for leave of court to file a third-party complaint against C. The court issued an order disallowing the third-party complaint. May D appeal from the order? Yes. Such an order would finally dispose of D's rights to implead E. BDA de Jesus versus Balagot 20 Scra 950. Section 13. Answer to third or fourth party complaint. Q. X car collided with P's car, destroying the latter's car. P sues the insurer to recover damages on his car insurance policy. The insurer files a third-party complaint against X. May X, in his answer to the third-party complaint, raise the defense that P's car was, at the time of the collision, being driven by P's friend, who did not have a valid driver's license, thus violating the authorized driver clause of the car policy and barring P from recovering thereon? The answer is yes. Under Section 13, Rule 6, a third-party defendant may allege in his answer defenses that the third-party plaintiff may have against the original plaintiff's claim. The violation of the authorized driver clause is a defense that the insurer may have against the claim of the insured P, yet this may be invoked by X in order to defeat or negate the insurer's claim pursuant to Section 13, Rule 6. Q. P filed a collection case against D, who had acted as a surety in a loan extended by P to X. D in turn filed a third-party complaint against X for indemnification. It turned out that X had already paid his loan to P, even before P had brought his suit. May X file a counterclaim against P for moral and exemplary damages for bringing a malicious and unfounded suit and causing X to be dragged into court? The answer is yes. Ordinarily, a third-party defendant may not file a counterclaim against the original plaintiff. Since the original plaintiff is not an opposing party as to him, however, under Section 13, Rule 6, the third-party defendant, in proper cases, may assert a counterclaim against the original plaintiff in respect of the latter's claim against a third-party plaintiff. Here, X counterclaim is connected to the loan transaction subject of the suit filed by P against D, Section 13, Rule 6. And that's the end of Rule 6. Rule 7 coming up. Please forgive me for this recording, particularly this recording. I have not done any edits, so some pronunciations and even the intonation is not really this good. If you have any suggestions, please drop your comment. And if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. I still have a lot of pages to read. That is why I'm a bit in a rush. So please bear with us. Thanks.